Hi guys, Mark Dawes, NFPS Limited, and firstly thank you to all of you who responded to the last blog post and the last video we put out regarding the government's intended ban on the use of prone restraint and also the Supreme Court ruling on the right now for families to sue the MOD for negligence where their relatives have been killed due to not being given the correct kit or the appropriate training. And this has led to a really interesting debate because at one end we got people saying, look, we need to get rid of this prone restraint, it's too liable, it's humiliating, it's degrading, and it's been implicated in quite a few deaths. To the other extreme, where people have said, look, if they get rid of this, then we're going to be left vulnerable. It's the only technique that we can use to actually control people in, and without that technique, we're going to be liable. Now, there's a whole raft of issues in between this as well. So at least the debate is open, and we'll keep you informed and updated as we hear more about it. But one of the emails we got is quite interesting, and I'd like to read it to you. It says, it's from a gentleman who's quite concerned about this technique being removed, but we've actually come across organisations as well where other techniques have been removed. So I thought I'd read you his email and then I'll give you a response from a very eminent barrister. And excuse me while I read it off the iPad. It says, where does an organisation stand if they take certain physical skills out of a physical restraint or defensive training programme so that staff are no longer taught them, and then a member of staff gets injured during a restraint or assault at work that could have been prevented had the skill or technique been left in? Could the company, the training organisation, be held liable for negligence under an act or an omission for the injury sustained on the basis of the member of staff's claim that they were denied using a skill which, if applied correctly, in line with the training given and as part of a tactical hierarchy response options, would have prevented the injury from being sustained? Well, the short answer to that is yes. If an organisation decides on a whim to remove a technique because they don't like it and there's no real justification to that, then yeah, they're liable. They're liable for the techniques they use and the techniques they don't. Now, we put that to a very eminent barrister, and this gentleman has been at the bar for 17 years. He's highly qualified, very competent and hugely experienced in these type of cases. And this is his response to that question. He says this: any organisation which does not teach and utilise the full range of occupational techniques and teach and train the appropriate occupational restraining techniques when these are necessary for the particular work are engaging in negligent training and negligent work practices. This means that liability and negligence will fall upon the organisation in situations where an injury is sustained at work by an employee which could have been prevented had the appropriate technique for restraint been used. Liability for work injury of an employer is strict liability when it comes to work training and work practices. Accordingly, where the appropriate techniques are either not taught to employees or are not authorised for use, this is clear employer's workplace liability for negligence. And the liability extends to all acts or omissions which could have prevented the injury, and damages result to an employee injured in such circumstances, as will sick pay. So there you have it from a very eminent barrister, is if organisations actually remove techniques without any justification on a whim, and that results in someone being injured, seriously injured or killed, then the employer is liable because they have a strict liability to provide training, information and instruction and supervision, and that's is part of the Health Safety at Work Act. Now, also below this video, I've got the view of Mark Williams. Now, many of you may know Mark. He's a very experienced expert witness in his own right. He's a very competent physical skills professional. He spent time training police officers. He was on various Association of Chief Police Officers panels. And Mark's been kind enough to say, look, I've got an opinion on this. Let me share it with you and with your people. And I've got Mark's opinion in full in writing underneath this video. So please have a look at this because it's really worthwhile getting the opinion of someone who's got a very balanced approach to this and who actually has got a lot of experience in this field. So when you've finished listening to me, just go down beneath the video and have a read of what Mark says. I've also put this to a very, very senior and very qualified Director of Health and Safety who is the Director of a large criminal justice system. I put the same question to him. And his response was exactly the same. If the employer removes a technique without consultation, without justification, and without any proper assessment of the risk, and that results in someone being hurt, then the employer is liable. Now, the key with all of this is the assessment of risk. Whether you keep it in or whether you take it out, that needs to be justified by a thorough, suitable and sufficient assessment of risk. And without that, there's no evidence for why that decision would have been made. So a risk assessment is key. It's the hub, it's the critical point of where all of these discussions should start. Because if you don't do a risk assessment, what are you basing your decision on? Because if a situation goes badly wrong and it ends up in court, or a member of staff suing their employer, or even a service user suing their employer for an injury sustained, then what the court's going to want to see is documented evidence of how someone came to that decision. And as Mark Williams says, we'll start from the smoking gun and work backwards. Why was that decision made? Who made the decision? What was the justification for that decision? Where's the evidence base that supports the justification? And the key tool for this is risk assessment. Now, when we look at prone, obviously the Human Rights Act comes into play. And in Article 2, the words absolutely necessary are used. Now, absolutely necessary is defined by human rights case law. And what that means is all organisations have a positive and proactive duty under human rights to promote and preserve the right to life. All public organisations and all private companies who are undertaking public functions have this duty. Now, if it comes to using any technique where there is an inherent risk to life in our world, in the restraint world, then that has to be qualified and justified under the words absolutely necessary. And absolutely necessary means that it needs to be assessed, it needs to be planned, it needs to be organised, there needs to be appropriate training, instructions and briefings given to staff. And you can find all this under human rights case law under Article 2. And it does not mean that we'll just keep it in and see what happens, and if it goes wrong, it's down to staff who've made that decision at that moment in time. This is a duty on the organisation, on the public authority, or on the private company acting that way. And the key to this planning and organisation and control, as has been defined by case law, is an assessment of risk, a full risk assessment. Now, Mark and I have found over many years, Mark Williams obviously I'm talking about again, that when we deliver courses, staff tell us that they have to do risk assessments, and they're told by their employer do a risk assessment. And in many cases, they're given the paperwork and told to get on with it. Well, if they don't know what they're doing and they don't know how to do a risk assessment, then that risk assessment by default is not going to be suitable and sufficient, and it's probably not going to stand up in court. So what we've done as an organisation, and we've been planning this over the years at the request of many people who've asked us to do so, is we've got a BTEC Level 3 risk assessment course, and we've just put all that online, and that's going live on Friday. So if you want to be trained properly and you want to cover all these areas, then have a look at the course. You have a look at it. If you want to buy it, you can do it. It's all online, and you can do it on your computer, your laptop, your iPad. I think you can even do it on your smartphone. You can view all the videos. And if you've done the Reasonable Force course, then you'll get an idea of how we're delivering these things now. And at the end of that, when you submit your work, you can actually qualify for a BTEC Level 3 unit certificate, BTEC Level 3 award in risk management and assessment. And this is going to teach you step by step how to do risk assessments. And what's unique about what we're doing is we're also going to cover the manual handling aspects of restraint as well, so how the manual handling regulations and principles apply, and also how to risk manage violence at work situations. And we're going to give you loads of documentation. We're going to give you loads of bespoke documentation that we've developed over the years specific to violence at work issues, so that's available for you too if you wish to go down that route. But the fact of the matter is this: whether you keep a technique in or whether you take a technique out, the justification for that you will have to prove if you are the training organisation or if you are the commissioning authority is in your documented evidence of how you came to that decision. And the best way to do documented evidence is to do it to a recognised standard of which a risk assessment is. So I hope that clarifies a few things for you. If you have any questions, please email us or get in touch. We're more than delighted to hear from you. And if we can help you in any way we can, we'll be delighted to do so. So that's all for now. But please read what Mark Williams has written. It's right below the video. And take that information on board and enjoy it. Speak to you soon. Thanks ever so much.